Okay, everyone. Welcome to the Society of Construction Law Case Law Update, our first for 2026. Thank you for joining us online. This presentation is being recorded and will be made available in the members area, so you can rewatch it as many times as you would like at your leisure. And I'm joined on our esteemed panel by Stuart Robertson, and Brendan Cash, both from Dentons. They're going to lead off with their respective cases, and I'm going to follow up with the third case that we're covering, and then hopefully we'll have some time for questions. Please put those questions to us in the chat option, and they'll pop up in the Q&A, and we'll try and work through them in the time available. I'm sure you all know the drill by now. So without further delay, I will hand over to Stuart to kick us off with Burt and Grant.
Thanks very much, Jonathan, and to SCL. Hello, everybody. I'm going to kick off here with Burt and Grant, and I like to open these things with a slight apology in that I know at least one SCL member was counsel on this case, and there may be others that were actually parties or affected by the case, so I'll do my best, but you may know a few more details. If you do, throw them in the chat. So what's Burt and Grant all about? It's a High Court proceeding and a judgment of Associate Judge Britton issued on 29 August last year. It's an application by a committee of subcontractors asking the court to reverse or modify decisions made by the liquidators of two Stanley Group companies, specifically addressing the issue of what happened to the retentions. So by way of background, there are a number, or were a number of companies in the Stanley Construction Group. This proceeding relates to Stanley Construction Limited and Stanley Construction Auckland Limited. I'll just refer to them as Stanley. Not surprisingly, they had a number of projects on the go, and they engaged various subcontractors from whom they withheld retentions. Quite wisely, prior to the retention scheme being first introduced into the Construction Contracts Act, the company's directors passed on each company a resolution, and it's worth me just reading it out for you, that all retentions payable are held, quote, on trust, end quote, for the beneficiary being the subcontractor from whom they are held. The company also dedicates all retentions receivable, brackets, also held on trust with us as the beneficiary, close brackets, as being available and as the liquid asset and a surety for their payment. So quite forward thinking. What that resolution, I understand, means is simply two halves. First, they said they were holding subcontractors' retentions on trust. The second half is that the retentions that their principals owed Stanley would be treated as available, as accounts receivable, available liquid assets for payment of retentions to subcontractors. So what happened next was, shortly thereafter, we had the retention regime kick off on 1 April 2017 under the CCA. And then there's a pause for just over 2 years when on 5 September 2019, the Stanley Group of companies went into liquidation. The very following day, they also went into receivership. The two Stanley companies at issue here owed creditors approximately $6 million and faced subcontractor claims for retentions of approximately $2.1 million. There were no retention funds available. As a result, the liquidators went out and brought proceedings against the company directors in an attempt to recover those missing retention monies. That proceeding settled with two directors making payments in settlement in respect of the missing retention amounts, and they're referred to as the settlement payments. The liquidators were also luckily enough to recover through separate efforts retentions owed to Stanley from their principals, and those are referred to as the recovered retentions. Interestingly, though, rather than those two pools of money being set aside for retentions for subcontractors, the liquidators took the view that they formed part of the general pool of assets of the companies and promptly then paid their own liquidators' fees out of them. Interestingly, and maybe it was a bit imprudent of them not to do this, they didn't first go to the court to seek directions confirming that was appropriate. And you might ask, well, that was a bit rash, but the general thrust was these were efforts made by the liquidators through one proceedings and other methods to recover monies, and so they took the view it went into the general pool. It wasn't for a specific purpose. The subcontractors were suitably upset and claimed that the liquidators should not have applied those funds to pay their fees, and that the funds should have been held in trust for their benefit. So where do we start? The associate judge was bound by, and correctly recognised he was bound by, the decision in Ebert Construction. And you may recall, unhelpfully, this is where Justice Churchman decided that while the retention scheme says retentions money was to be held on trust, you still had to apply ordinary principles of trust law before a trust was even legally formed. He found that in the majority of the cases, if not wholly, there was no trust, and therefore directions were sought as to what was to happen next. You'll also recall that the outfall of that judgment was a substantial amendments made to the retentions scheme, and the new scheme came into effect on 5 October 2023. The interesting question is, and when you read the judgment, which I encourage you to do, the first half of the judgment is dealt with introductions and some in an ancillary skirmish. The actual second half of a relatively short judgment deals with the two substantive questions, and it's worth having a read. So first, dealing with the settlement payments, that's the ones that they recovered from the directors through the court proceedings. The liquidators relied on the fact that there were no funds held on trust at the commencement of the liquidation. Put aside the moment that was a breach by the company and its directors. But that's the first principle that they argued. The liquidators then argued, once a breach of directors' duties had been established, any compensation payable constituted a general asset of the company. Well, Associate Judge Britton wasn't having that, and he's held that the settlement payments were trust property, and he reasoned it this way. The trust was created under the CCA as soon as the relevant amounts were withheld by Stanley. And I have to say that's clear from the original retention scheme and the amended scheme. Stanley breached its obligations as trustee at that point in time by failing to hold the retentions either in cash or in liquid assets. Second, the liquidator's proceedings, unhelpfully for the liquidator but great for the subcontractors, alleged that the directors had assisted in a breach of that trust by the companies. The settlement payments were accordingly a restoration of trust funds. It didn't matter that the directors were being sued in proceedings under the sections 131 and 137 of the Companies Act for breach of directors' duties. Finally, the associate judge held when the settlement payments were received, the company's trust obligations were still continuing, even though the fund was zero. The liquidators were required to ascertain what the company's obligations were under those trusts and as trustees, and to administer the trusts by receipting those funds in favour of the subcontractors. So, insightful decision by the judge, and round one in favour of the subcontractors. Second, though, is the recovered retentions from the principals. And you'll recall that back in the day, the relevant period, 2017 to 2019, the retention regime said you can hold retentions in the form of cash or other liquid assets. The liquidators submitted, because payment of the retentions to the subcontractors depended on retentions first being paid to Stanley by their principals, there was no liquid assets at the time. Now, that sort of screams in pay when paid, pay if paid immediately to me. But the judge said that the directors were caught out by their own resolution, because they confirmed that within that was enough for a statutory trust to be formed, and that the statutory trust acknowledged that accounts receivable were an asset that the trust could rely on. So he rejected the liquidators' submissions, finding that a statutory trust had been formed, and that in any event, the directors' resolutions had effectively made a declaration of an express trust. He said there was no uncertainty as to any issue around the trust law for formation of that trust from the declaration. So, as we've got up on the screen there, we're sharing with you some key learnings. First is missing retentions that are subsequently recovered by a liquidator and by a receiver, and you'll remember EBIRT was about a receivership, are still held on trust for the contractor. It's not, you don't get the proceeds of proceedings and then use them to pay your own fees, and then they go into the general pool of assets. Second, I think Associate Judge Britton was being quite clever in putting aside technical arguments, albeit he was still bound by the EBIRT decision, and in future courts are going to be unlikely to accept those sorts of technical arguments about how and when a trust will be formed. This signals that the courts are going to be more readily open to confirming a trust had been formed in this sort of circumstance. Jonathan, that's me. I'll leave you to hand over to our next esteemed speaker.
Right. Hello. Hopefully people can hear me. I couldn't hear Jonathan just then, but I'll assume that everything is going fine unless people flag up otherwise. I'm talking about another High Court decision. I suspect I've got the pronunciation of this wrong, but I think it's the Hasiah Family Trust versus Dream Home Construction Group. It's a case that has a rather unfortunate, as is often with the cases that end up in court, a project with a bit of an unfortunate history. So the family trust in that case had engaged a contractor, Latham Construction, to construct 2 residential houses on a property, but that first construction contract did not go very well. There were disputes between Latham and the family trust, particularly over what was said to be a number of defects in the work that Latham Construction had done, and that resulted in essentially an agreement between those parties, between the trust and Latham, to bring that original construction contract to an end, and the family trust then engaged Dream Home to take over the work. And Dream Home, under its own sort of bespoke contract, agreed a fixed price lump sum in order to complete these properties. And as you might think, the fact that it agreed a lump sum price to complete the work on these properties is probably the source of the problems that arose subsequently, and is relatively, at least in the larger commercial matters that I tend to deal with, an unusual situation where one contractor takes over from the work of a previous contractor and where there are known to be defects in that prior work. What typically would happen in my experience in relation to that is that the contractor taking over would not agree a fixed price, certainly not for the entirety of the work, and would make very clear that it was not assuming any responsibility for the work of the previous contractor or in fixing or attending to that work, and that would be so that it's not taking responsibility for it. And as we'll come on to see, that really becomes one of the core issues and lessons to be learned from this case is the danger of taking on a project where a previous contractor has been involved and there are issues with their work. So what then happens when Dream Home takes over is that the whole project goes quite slowly and suffers from various delays, and a range of issues come up between the trust and Dream Home in relation to defects and issues in the work being completed. To such an extent that at one point there's effectively a 6-month pause in the project when it was already running late, while both parties engaged building surveyors or experts to come along and do inspections of the properties, review lists of various issues and defects, and engaged about what was and what wasn't a defect, etc. And one of the underlying issues in relation to all of that is that amongst all these issues was a number of issues that essentially had their origin in defective work of Latham Construction, the first builder that had started on the project. So after this break had happened over a 6-month period, that sort of came to an end. And there was sort of agreement over a range of issues that were going to be addressed and sort of some timeframes as to when work would be completed by, but work wasn't completed within those timeframes. It seemed to go very, very slowly. That ultimately resulted in the trust serving a notice of default under the contract, alleging both unreasonable delays by the contractor and also unresolved defective work, and they then trust then engaged another contractor and completed the work. And this came to court because the trust sued Dream Home in sort of the usual way that you might in these circumstances, essentially claiming the additional costs that had occurred completing the 2 properties after it had terminated. And you had a dispute that was then basically around, well, was the trust entitled to terminate? If so, what damages and liabilities and losses would it be able to recover? And then there was also a subsidiary issues around what the obligations were of Dream House as a departing contractor in terms of providing documentation to support an ultimate application for a code compliance for the properties. So one of the, against that background, sort of the interesting things that come out of this case are really the following. The first of them is this issue of the contractual scope, because it played into the issue of why had Dream Home being delayed? Was it being delayed by matters that were outside of its control? And that was its position. And in particular, it said, really, we're struggling to complete this build on time because of all the issues with Latham's work and the defects that we're having to repair. And what the court concluded there is a fairly orthodox position, but it is one that is worth remembering if you're ever taking on work where another contractor has started, which is that basically a builder takes the works as they find them, and in the absence of express terms stating otherwise, the builder is responsible for completing all of the works that they have taken on, including all matters that are necessary to do that. And in this case, that is what Dream House had agreed to do, with the consequence that it had assumed responsibility for remedying the issues in Dream Home's work within the fixed price that it had given and within the time frame that it had agreed to complete the work. And this is why, as I averted to earlier, in all of the situations that I have dealt with over the years, which have principally been in the context of insolvencies where the original contractor has gone bust and acting for principals who have then had to engage new contractors to take over the work, the new contractors make it very clear in the express terms of the contract that they have no responsibility for that previous work, that if they're fixing that work, they do so on an open book, cost reimbursable charge up type basis, that they're not giving any warranties, etc. in relation to it. In other words, they do what Dream House failed to do in this case, in which the judge highlighted, which is absent express terms, you're responsible for everything. So if you're a contractor doing this work and taking over another, make sure you have those express terms in there that clearly limit what your responsibility is and the basis for your price and your time for doing the work. So that's the first sort of interesting lesson that came out of that. Off the back of that, the court went through the various delays that had happened on the project, and essentially, not surprisingly, against the background of that legal conclusion about what Dream Home were responsible for, concluded that they had delayed the work, and in particular, while they could be forgiven for some of the delays, especially because there'd been the 6-month shutdown, there was a fairly orthodox analysis that basically said, well, you haven't, once that shutdown had finished and work had restarted, you weren't dedicating the resources, progress wasn't being made, you didn't remedy that default post the trust giving the requisite notice under the contract, and as a result, they were entitled to cancel. Now, the other ground of cancellation that was put forward in the case was that that Dream House had not essentially remedied another number of defects in the work. Now, that was all a bit messy because, again, there was in terms of the records you had at the time, some things it was acknowledged that they had fixed, some things were really issues that arose from Latham's work. Some of these were acknowledged defects that they accepted they had to remediate, and Dream House's position was that it was indeed taking steps to remediate that work. The judge's conclusion here, again, an orthodox legal position, but one worth being aware of in the context of looking to cancel a contract, which is if the defects can be remedied before completion of the work, the builder has not breached the contract. In other words, what the builder is engaged to do is to build and provide a compliant house that meets the requisite standards in the contract and otherwise at law at the conclusion of the works. And the fact that there are defects along the way does not mean that the builder is in breach. The builder is only in breach if they make it clear that they are not going to fix defects which are their responsibility before they complete the build. So the court's conclusion was that the trust could not rely on defects in the work as a ground for cancelling the contract. But of course, that didn't matter in this case because the court had concluded the trust was entitled to cancel as a result of the delay. The other couple of things that are just worth noting in the context of this decision there was a claim against the director in this case, alleging a personal duty of care, as that largely essentially revolved around the failure of the builder to complete the works in time. The court, not surprisingly in my view, reached the conclusion that there was no personal liability on the director because the obligation to complete the works within the required timeframes and diligently and so forth was a contractual obligation and not a duty of care that was owed and taught personally by the director. So then the final interesting aspect, which is up there on the screen, is the homeowners were complaining that there was a raft of documentation, either producer statements or similar, or guarantees and warranties from sub-trades and suppliers of materials, or the manufacturers of them, that they needed and wanted and should have been provided, particularly for the purposes of obtaining their code compliance certificate. And on that point, between expressed terms of the contract and an implied term that the court readily accepted, the court said the builder was under an obligation to provide the necessary documentation in relation to its work. And so as a result, and was ultimately found to be in breach for failing to provide some of the documentation that was identified as being missing by the homeowners. So perhaps not surprising, really. That documentation from the builder and its subtrades is very important, getting a code compliance certificate. And so it's a useful reminder that a builder can't simply walk away and refuse to provide that material, even in the termination situation. I think that's me.
Thank you very much, Brendan. Just to reiterate for those of you that have joined us during the course of this presentation, that we will be all magically appearing on the screens at the end after I've just finished talking about this next case. I've got a couple of SCL notices to rattle off, but then all three of us will be available to answer any questions. So do please put those in through the chat function and we will endeavour to deal with them as we can, time permitting. Now I'm going to be talking about the Van Ord UK Limited and Allseas UK Limited case, which is a slightly older case, 2015 from the UK, but it is a case of Justice Coulson, and we had the honour of having his honour come and speak to the SCL relatively recently. It's also on the topic of credibility of expert witnesses, and in the context of construction disputes, they are absolutely critical and a huge part of disputes, not only before the courts but in the adjudication and other ADR contexts as well. And the credibility and performance of experts is a somewhat uneven experience. And that's also reflected in the recent changes to the High Court rules, which have been promulgated in force since the 1st of January, with the court's expectations around the behaviour of expert witnesses and the court's expectation that they present evidence in a certain way with obligations to the court and also obligations around competence and the ability and willingness to caucus matters, hot tubbing or whatever other mental image you want to throw up. That wasn't intended as a direction about the ability of experts to talk to each other. So just on the Van Ord case, the background to this one, it was, and I must add, by the way, I'm sort of standing in for Madison from Dentons in Wellington in this context, so just a shout out to her and to her team for the notes for this case, which were received with many thanks by me. The claimant made 3 disruption and prolongation claims against the defendant, valued at around £2 million by the time judgment was issued. But a lot of it hinged on the claimant's quantum expert, a Mr. Lester. Now, Mr. Lester admitted to the court that this was his first time preparing a written expert's report and giving evidence before the High Court. And during a break in examination, he abruptly disappeared from the court. which I'm sure would have raised a few eyebrows. And in his judgment, therefore, His Honour set out 12 criticisms of Mr. Lester's evidence, and they are, I will briefly go through them, but they've been carefully considered, and they do provide something of a checklist and things to look for or perhaps not do when considering how expert evidence is to be presented. The first is that the expert repeatedly took the claimant's pleaded claims at face value and did not check whether the underlying documents supported them. In particular, he uniformly utilised rates that the claimant said the parties had agreed to in other contexts without carrying out his own quantity surveying. He, second point, only looked at witness statements prepared on behalf of the claimant and did not read those prepared on behalf of the other parties, which is a particularly significant failing. The expert refused to prepare quantum evidence in respect of the other side's case. He did not formulate claims based on the actual costs incurred by the claimant and consequently failed to address whether the claimant had suffered any actual loss at all. The expert was repeatedly caught out during cross-examination on errors that had already been pointed out by the other side's expert witness months earlier, but note earlier comment that he had not read any of that material. The expert disowned his own report immediately before giving oral evidence, which I'm sure cheered up his own counsel tremendously. The expert repeatedly accepted that parts of his report were confusing and potentially misleading. The expert did not appear to have looked at schedules attached to his own witness statement, and the expert made repeated assertions in his statement that appeared to be his own views, but which it later became clear actually came directly from discussions he had had with other witnesses for the claimant. The expert falsely claimed that he had prepared schedules to his statement, which it later became clear were prepared by the claimant, and he admitted that he had preferred to recite what others had told him over checking the claims himself. And finally, he admitted that he had never considered valuing the line items by reference to fair and reasonable rates, even as a cross-check. So a bit of work to do in that area, and it'll come as no surprise to anyone that Justice Coulson concluded that Mr. Lester was not an independent witness and opted to disregard his evidence in full. And so this is in the context of evidence that was obviously considered to be ready for presentation at trial and was done so in the context of a full hearing. And that list might seem extraordinary, but that's what the judge was faced with, and that's why he reached the decision that he did. And obviously the expert witness is not the only contributor to many of those matters raised by His Honour being an issue. There has been similar commentary from more recent cases in the New Zealand courts. In the Cridge and Studorp case in 2021, Justice Simon France made the following comments about expert evidence being given on behalf of the claimants. It's worth quoting. Some of the plaintiff expert witnesses were not, in my view, reliable, and others strayed outside the area of expertise. This significantly reduced the weight that could be given to their evidence and weakened the plaintiff's case. And in the body corporate 188529 and North Shore City Council case in 2008, Justice Heath commented on the quality of the expert evidence given before the court in that case. What became clear to me during the course of the hearing was that the intensive involvement that the experts have had in problems arising out of so-called leaky home syndrome has tended to harden opinions on specific issues. That had two consequences. The first was that often, it seemed to me, the opposing experts took intransigent positions on issues that seemed susceptible of expert resolution. And second, I perceived that occasionally personal views tended to override more objective assessment of a situation. I am troubled by some of Mr. Bailey's evidence. He tended not to answer difficult questions directly, but rather to skew his answer to deflect the questioner and to avoid the need to accept valid criticisms of the council's actions. In that regard, Mr. Bailey sometimes strayed into the arena of the advocate. What that means is what I take care when weighing his evidence against that given by other experts. So the key learnings coming out of that collection of judicial authority is that all expert witnesses should be familiar with all of the evidence in a case, and when preparing their evidence refer to what they've done and the assumptions that they've made. They should be impartial, and they owe that obligation to the court, and they should also be prepared to address difficult and contentious issues, and that can be quite a bit of a problem if they are preferring instead to stray into the role of an advocate. That might be very appealing to a party when their evidence is obtained, particularly if the party has had a strong role in selecting the expert as being somebody that's supportive of them. But the problem is that when that's often tested subsequently, it can come a bit unstuck because their preference and their inability to make concessions can make the evidence a lot less compelling than it needs to be to succeed in the case. The other thing I should note, and it's a developing area, is that there have been issues now creeping into cases, not in New Zealand as so far as I'm aware, but certainly in some jurisdictions overseas, where expert evidence is being given by human experts in the court context, but it becomes apparent that a large amount of what they're presenting was not generated by them, but by the use of generative artificial intelligence platforms in terms of carrying out calculations. And in some instances, they have been unable to explain to the court the basis for the calculations that are set out in the schedules and other things appended to their reports, because they didn't do them. They provided the inputs for the generation of that material into another system, and therefore can't necessarily explain the processes and assumptions made by the system in generating the material. To a certain extent, this sort of usually happens, but it has become quite telling in some cases, and it might be something that we'll explore more, I'm sure, in future case law updates. So I did rather roar through that, but it was worth listing out the issues that Justice Coulson felt necessary to enumerate about the unfortunate expert witness in his case and the judicial comments made in the other cases chosen as examples. I should note that the citations for those are in the notes of the PowerPoint for this case law update, which will be in the members area as well. So in case you thought I was going too fast and you missed them, they will be there in writing for you. I'd also like to, as I mentioned, just raise a notice for the SCL. Melanie has reminded me that we are very much looking forward to seeing you all at our March meeting. We're pleased to have Dave Barr expanding on the discussion on insurance issues that tie in with the proposed proportionate liability legislation and the related insurance discussion, which is a really significant part of that change and the assumptions that underline it. So the dates that we're looking at are Tuesday the 3rd of March in Wellington, 4th of March in Christchurch, and the 5th of March in Auckland. Registration will open soon, and we will be looking to have one of those sessions live streamed and made available to people who can't otherwise attend, but I can't tell you at this stage which one that will be or which date it will be, but it'll be one of those 3 dates coming out of those centres. So now we're going to magically rejoin as a wee panel on your screens, and hopefully we've had some questions coming through in the Q&A. Okay, the first one that I've got is, and might need to be expanded. I'll start reading it at the top, but it says, thank you for today's presentation. With regards to a main contractor holding retentions on a subcontractor that has gone into liquidation, so this is, I think, a question for Stuart. When do those retentions need to be released to the liquidator? At the end of the contractual retention period, at the end of the warranty period, which that subcontractor is responsible for, or under other clauses from the Building Act and Consumer Guarantees Act, etc.? Oh, Stuart, you're muted.
I'm back on. What a good question. I can't bring up the Q&A, but whoever asked that is a very vexed and unclear situation. It doesn't pivot on any consumer legislation. The release of retentions is set by the contract. But if the head contractor who's holding subbies retentions is placed into liquidation, the ordinary step is that the liquidator will then disavow or decline the contract, and wisely so. Otherwise, they expose themselves to personal liability, and therefore the principal has to go and find somebody else to finish off the job. I think it's a question that the court's going to have to resolve, and in fact, I'll defer to both Jonathan and to Brendan if they know a better answer. But the liquidators, once they're in receipt of those monies, presumably have to release them. Their company is no longer in contract with the principal. The money is not the liquidators, it is the subcontractors, and it's up to the principal to either re-engage the subcontractor afresh, or if there's some form of continuity agreement in place, they will continue to work. But the retentions withheld are in trust for the subcontractor. I don't know if there's any other contrary views from the panel.
No, I would agree with that. The funds are held in trust for the subcontractor. The liquidator now, under the most recent changes, does have the ability to deal with those funds, whereas previously they had to go off to court for clarification. Now they can deal with them. The issue, of course, is the complexity and cost of doing so, particularly if it's disputed and that's money that's sloshing around that other people think is theirs. But really, it isn't a matter for the company that's in liquidation anymore at all. It goes back to sit with another layer in the cake, so to speak. And I think that the problem arises when people look at retentions in a sort of slightly odd way, as though they're sort of held on a project basis. And sometimes that can encourage people to hang on to them when they shouldn't, and it gets you into sort of pay when paid territory, which is a bit unfortunate. But no, I would suspect on that question that they would need to be released by the liquidator because they're not an asset of the company.
The one comment I will make is that on a number of liquidations involving head contractors that I've been involved in, the messiness around retentions is such that either in the agreements that have been put in place or in what have effectively been sale transactions that have been done either just before or just after liquidation to essentially sell the job back to the principal, I've sorted for the subcontractor retentions, which have been held in trust by the head contractor, to essentially be transferred to the principal to continue for them to hold in a context of the subcontractors continuing on the job with the principal.
Yep. But if that doesn't occur, you've got to remember, the person who asked the question, the principal is already holding retentions from the head contractor who was responsible to complete all of the work, whether they subcontracted or not. So the principal still has its fund to apply to any defects in the works.
Yes. Yeah, so that's still available.
Yeah.
Very good. Well, hopefully that's answered the question. We've got one from Mark Holland. He says, cross-pollinating Brendan and Jonathan's presentations, does the panel have a view on criticism of the plaintiff's quantum evidence in the say case, or he say case, with the plaintiffs, brackets allowing for the counterclaim, recovering a fraction of the originally asserted quantum? Brendan, I'm going to say that's mostly one for you, isn't it?
I think what I'll say is this is having done a few of these things over the years, there can be a tendency for plaintiffs' quantum evidence in claims to go over the top, because there's a tendency to throw everything in possible and to not recognise that actually some things are clearly beyond the limits. And the second thing that I see happen is that you then don't get what should be happening is an engagement between the respective experts on each side to genuinely try and agree what can be agreed and work that down to as little as possible. And I think decision makers don't find quantum evidence to be the most thrilling piece of evidence that they have to deal with in their cases. And what they are really looking for are the two experts to get together and engage meaningfully on the topic and actually come to some sensible resolutions and have some very clearly defined and limited disputes between them where there are genuine arguments. And I think the risk, if that doesn't happen, where you get inflated claims, say on the one side, and no real engagement between the experts on the other, and everyone sticks to their positions, is that the judges, decision makers, get a bit annoyed. And they can then be quite harsh on the party that they think has not really been realistic in terms of both what it's put forward and the engagement on those issues. And that's what you see in that case. I mean, they started off with a claim increased cost to complete of well over $1 million, and the court brought that down to about 600,000 by the time it had cut out several large items, which then took the overall claim down to the core claim for the additional cost to complete into sort of the mid threes, from up around sort of the high 600s, 700s. So yeah, I think the danger here, which both your discussion, Jonathan, of Van Ord, and if you look at that aspect of that decision, is you need to be careful about what you put forward, and then you need to have meaningful engagement. And if you really have things that you should be conceding as a defendant, say quantum expert, then you should concede them and you should engage with them, and you shouldn't adopt extreme positions that says, no, I'm certifying zero, when actually the sensible number is either what the plaintiff has put forward or something lesser. And equally, as a plaintiff, putting forward numbers that are unrealistic and then sticking to them and not conceding and dropping them off during that process just sets you up to have a claim that actually has no meaningful basis, and suddenly you see, a third to between a third and a half of it wiped out.
Yeah, I agree completely. I mean, there is. I don't think anyone's done an analysis on it, but I wouldn't be surprised if most situations where judges have to grumpily get out their calculators and try and do exercises that the experts have failed to do so, is that much to everyone's surprise, you get roughly half what you asked for. That's after lots of comments about the fact that that's never what anyone does, and it's all being carefully mathematically considered, and contribution, this, that, and the other thing, and then weirdly you get a number that's pretty much half or slightly above it, so that it doesn't look too suspicious. But that's because the court's going, well, hang on a minute, you guys are all experts, you've got all these letters after your name, you couldn't agree, so what do you think I'm going to do? After I finish dealing with you, I've got 5 rape trials to deal with. And so, some Class A drug stuff. That's not what I do as my day job. And if you guys who are experts couldn't do it, then I'll just pick a number.
I don't think you can underestimate the importance that a quality expert makes in this context.
Yeah.
And in that context, lawyers sometimes reach the conclusion that the expert who agrees with everything that they and their client says is the right expert and the best expert for the matter. The short answer to that is no. You want the expert who will obviously help you present your case, but is going to test it, tell you, no, this is rubbish, this won't fly, etc., so that what you end up presenting is the best case, not the wishful case that's never going to be achieved.
Right. And that also can sometimes stop the wonderful feeling you get in your heart when your own expert completely folds on the stand on every single aspect of their evidence, and then says, I think that went rather well, don't you?
And actually, I think in that regard, one of the things is to look for is for experts who do work for both sides of the fence.
Yes.
i.e. not people who only ever appear for a plaintiff or only ever appear for a defendant. I often think in that context, one of the great things that, for example, you see in the English system in the context of the criminal law is that the criminal bar in the UK both acts as prosecutors and as defendants. So they never entirely all have a view that, all people up as defendants are crooks who have to be put away, and they're not sitting as defendants lawyers all the time going, oh, well, all prosecutors and the police are corrupt scumbags who are coming up with evidence, etc. I think a bit of balance by doing work for both sides is a great sign for a quality expert that will help avoid some of these pitfalls.
I don't think we've got any other. Oh, well, we do. So from Andrew Shallard, is there an onus on a liquidator to go chasing unpaid retentions in order to pay those to a subcontractor?
Another good question. The obligation of the liquidator, of course, is to recover as much money for the company. And I'm not an insolvency expert, but that taxes my mind to say, well, the asset that's held in trust, the retentions, are not a company asset. Similarly with the receiver, a receiver is there to look after the interests of the debenture holder, of the appointer, not the assets of the company as a whole. So I suppose what Burt and Grant will now flag is that if liquidators were now going to think of embarking on proceedings to recover retentions, they should engage with the subcontractors, the affected parties, and enter into some sort of funding arrangement or at least some recovery arrangement. Certainly, eBurt and the Burt case, and now the amendments to the retention regime, provide for liquidators, receivers to be remunerated reasonably from the retention fund, and absent agreement from the beneficiaries of the retention, maybe they should go to court and get approval to do that, and the court can weigh up the merits of whether the expenditure is worth the risk of recovery.
Yeah, I mean, I think they're often best placed to do the chasing, in a practical sense, but they could be quite correctly criticised by the other creditors for not acting in the interests of the creditors of the company generally by chasing funds that are only of benefit to one particular creditor. But if that creditor and the liquidator have a clear understanding of the fact that the costs of that chasing is to come out of whatever is recovered, then I could see that happening. The other thing is that in the context of a liquidation where the whole performance of the contract has fallen away and record keeping and the availability of staff and so forth is problematic, and it's difficult to ascertain the status of works on site, it can be very difficult because money doesn't just become available simply because a party's gone into liquidation. It's usually triggered by it is triggered by the key clauses in the underlying contract in terms of the timing and also the conditions on the ground. So liquidators can't just press a magic button and say, we'll stop time there and you'll get all of the retentions. But I think it's worth having the chat.
I think it's fair to say, wouldn't it be, Stuart, that one of the issues in the Burt and Grant case is the fact that the liquidators took what I would describe as a reasonably robust view in not obtaining any directions or guidance from the court in relation to their steps, which can be seen in, say, stark contrast to what happened in the eBurt case, which admittedly was the first time this had come up, but nonetheless was PwC taking a cautious approach in going to the court to sort out how should we manage this situation, and I think this emphasises that there is some benefit in liquidators taking a cautious view when they're pursuing down these sorts of paths and making sure that they perhaps either have appropriate agreements, directions from the court.
Completely right. And eBurt also demonstrates that the court in that case came up with a with a result which was possibly contrary to the expectation of a large part of the industry, and certainly contrary to the expectation of Parliament, which felt somewhat aggrieved that all of their comments in Hansard had come to nothing.
Yeah.
Yes.
But on the one hand, I can kind of understand why the liquidators took the view that they did, given some of the bases of the claims, etc., they bought. But I think that was always likely to be a contentious issue as to whose money was that, who was entitled to the benefit of that money once it had come through. So not going to the court to get some guidance on that, I think, was a mistake, would be a fair way of putting it. And that's ultimately what the litigation established.
Yeah.
And we've got one last question, maybe, from Navinka. What was the contract in place between the parties in this A case?
They had their own bespoke contract that was Dream Home's sort of own, terms that they had developed. I mean, there are some, from the review of the case, it looks to be sort of a grab bag of things out of all sorts of contracts, stuff from that maybe reflects some of the other industry standards that are floating around, aspects that sort of reflects the 3910, etc. So yeah, it was a bit of a grab bag of their own mix.
Brings us up to we have that's it for our questions. If we got 3 minutes remaining, I'll just throw it open to the other panelists. Do you think that we will see a situation sooner rather than later where there is guidance on the role of generative AI in expert evidence, so rules for experts expanding on their obligations that are set out in the High Court rules around their use of tools that are independent of their own qualification and experience in generating evidence that they put before the court?
I'm not sure further rules are required. I think it'll come out of the case law, but the rules are reasonably clear. You've got to state your expertise. You've got to state the materials that you have relied on, what you've seen and observed, what measurements you've taken, and then the forming of your own views. So I think within that, it's broad enough that if a New Zealand expert was caught out like this using generative AI and couldn't substantiate matters, they would be falling foul of 943 and the Schedule 4 code anyway, without the express need for it, to stipulate generative AI.
Yeah, I'm not sure generative AI is a lot different from a range of software and computer systems that have been used by experts over a number of years. I mean, I can think of a range of modelling tools that computer modelling tools that get used in any number of cases. The key thing in those circumstances is the expert needs to be able to explain what the model is, how it generates its outputs, what the inputs were, what the outputs are, how it generates them, what it's showing, and be able to explain it and understand it. So I don't think the use of generative AI necessarily is problematic in that regard, but the experts will need to be able to be explicit about it and explain. And if they can't, that's when they're going to run into problems. If they can, then it's no different from someone running a hydrological model or a probability model in relation to the exploration for gas and your chances of hitting it and all sorts of things like that I've dealt with over the years.
Yeah.
Very good.
Wonderful.
All right. Well, thanks everyone. Thank you very much to Stuart and to Brendan for their time, and hopefully people got some benefit out of that. It's always good doing these things. We're going to be doing another one, not as a case law update. I think our next one on the update space is going to be people doing a quick capture of projects that they're working on. So focusing on other aspects of our society and an opportunity for some of the non-lawyers to talk about things from a project perspective, which I'm really looking forward to. But thank you everyone who tuned in, and take care and look after yourselves, and hopefully we'll see as many people as we can at the next meeting in March. Thank you very much.
Thank you.
Cheers all.
Cheers.
See ya.